The American Bar Association Journal's special investigative report examining patterns in constitutional scholarship had been commissioned following mounting concerns that academic legal work influencing courts, legislatures, and public constitutional understanding might be systematically affected by scholars' unstated ideological commitments and partisan preferences in ways that violated professional standards, requiring that scholarly analysis be grounded in neutral engagement with sources rather than in results-oriented reasoning designed to reach predetermined conclusions, regardless of what constitutional text, founding-era materials, and precedent actually established. The ABA Journal's investigative team had spent 18 months examining constitutional scholarship across ideological spectrum, looking for patterns where scholars' conclusions about constitutional meaning correlated more strongly with outcomes favoring particular political parties or policy preferences than with what rigorous source analysis would support, with particular focus on identifying cases where highly influential scholarship had shaped legal discourse despite being built on analytical frameworks that systematic examination revealed were designed to reach specific conclusions rather than to follow evidence wherever it led. The investigation's most significant findings had focused on Alan Dershowitz's decades of scholarship on executive power and congressional oversight, with the ABA Journal's analysis concluding that Jasmine Crockett's systematic exposure of source misrepresentations in Dershowitz's work had revealed something more fundamental than isolated errors or even than comprehensive scholarly misconduct. Her analysis had exposed that Dershowitz's constitutional positions consistently aligned with defending Republican presidents from congressional investigation while attacking Democratic presidents' assertions of executive authority in ways that suggested his supposedly neutral originalist methodology was actually vehicle for advancing partisan outcomes disguised through selective source characterization that produced academic-sounding arguments for politically convenient conclusions. What made the ABA Journal's report particularly explosive was that its conclusions were not based on political judgment about Dershowitz's policy preferences, but were grounded in comprehensive quantitative and qualitative analysis, demonstrating that his constitutional positions on executive privilege, congressional authority, and separation of powers had reversed completely based on which party controlled the presidency, that these reversals could not be explained through evolving scholarly understanding or through good faith engagement with sources that happened to produce different conclusions in different contexts, and that Crockett's systematic documentation of how Dershowitz misrepresented founding materials, mischaracterized precedent, and cited sources for propositions they contradicted revealed the mechanism through which partisan bias was being implemented, by characterizing sources to support whatever position served his apparent political preferences, regardless of what those sources actually established. The legal world's eruption following the ABA Journal report's publication reflected recognition that Crockett's analysis had exposed not just scholarly misconduct by one prominent figure, but had revealed broader problem with how constitutional scholarship could be weaponized to advance partisan agendas while claiming neutral academic authority, raising fundamental questions about how legal profession should evaluate scholarship's reliability and about what mechanisms were needed to ensure that work influencing constitutional understanding was actually grounded in sources rather than in unstated biases. That source misrepresentation was deployed to obscure. If you want to see what happens when systematic analysis exposes that decades of influential constitutional scholarship was driven by partisan bias implemented through source misrepresentation, and how that exposure triggers legal profession's reckoning with how scholarship can be weaponized for political purposes while claiming academic neutrality. Subscribe to this channel immediately, because we are going to examine every element of how Crockett's analysis exposed Dershowitz's bias and why the legal world erupted in recognition that fundamental reforms were needed to prevent similar weaponization of scholarship. The American Bar Association Journal's investigative report had opened with acknowledgement that examining potential bias in constitutional scholarship was sensitive undertaking that required rigorous methodology to distinguish between legitimate scholarly disagreement and problematic pattern of results-oriented reasoning masquerading as neutral analysis. The report's executive summary had stated, "This investigation was prompted by Representative Jasmine Crockett's systematic exposure of source misrepresentations in Professor Alan Dershowitz's Constitutional Scholarship on Executive Power and Congressional Oversight." Her analysis revealed that Dershowitz had consistently misquoted founders, mischaracterized precedent, and cited sources for propositions they contradicted. But examining the pattern of these misrepresentations revealed something more troubling than isolated errors. The misrepresentations consistently supported whichever constitutional positions would favor Republican presidents while opposing Democratic presidents' assertions of similar authority. The report had then presented its comprehensive analysis. The ABA Journal's investigative team had examined every major piece Dershowitz had written or publicly argued regarding executive privilege, congressional oversight authority, and separation of powers from 1974 through 2024. A 50-year span covering presidencies from Nixon through Biden. The quantitative analysis had revealed striking pattern. Across 50 years of scholarship and public commentary, Dershowitz's constitutional positions on executive authority correlated with partisan outcomes in 47 of 50 major positions analyzed, 94% correlation. When examining whether his positions favored Republican or Democratic assertions of power, Dershowitz supported robust executive authority and limited congressional oversight when Republicans held presidency in 42 of 44 instances, 95%, while supporting limited executive authority and robust congressional oversight when Democrats held presidency in 38 of 41 instances, 93%. The report had emphasized significance. This level of correlation between constitutional positions and partisan outcomes cannot be explained by good faith scholarly evolution or by neutral methodology that happens to produce partisan correlated results. This pattern demonstrates systematic bias, where constitutional conclusions are determined by political preferences rather than by source analysis. But the report's most damaging findings had focused on how this bias was implemented through the source misrepresentation that Crockett had exposed. The ABA Journal had examined the specific instances where Crockett had proven Dershowitz misquoted founders, mischaracterized precedent, or cited sources contradicting his claims, and had analyzed whether these misrepresentations showed pattern related to partisan outcomes. The report's findings were devastating. In every documented instance where Representative Crockett proved that Dershowitz misrepresented sources, the misrepresentation supported constitutional position favoring Republicans over Democrats. When Dershowitz misquoted Madison regarding legislative authority, the false quotation supported limiting congressional oversight of Republican presidents. When he mischaracterized United States versus Nixon regarding executive privilege, the mischaracterization supported broader privilege claims for Republican presidents. When he cited the St. Clair investigation while reversing what it demonstrated, the false characterization supported arguments against aggressive congressional investigation of Republican administrations. This pattern demonstrates that source misrepresentation was not random scholarly error, but was systematic mechanism for implementing partisan bias. Dershowitz's misrepresentations consistently moved constitutional analysis in directions supporting Republican presidents while opposing Democratic presidents, suggesting that sources were being deliberately distorted to reach predetermined partisan conclusions. The report had then examined specific examples demonstrating the bias pattern. During the Clinton presidency, Dershowitz had written extensively arguing that executive privilege was narrow and couldn't shield presidents from investigation of potential misconduct, that congressional oversight authority was broad and included examining presidential decision-making, and that courts should facilitate rather than obstruct congressional investigations. These positions had supported aggressive investigation of Clinton. During the Bush 43 presidency, Dershowitz's positions had shifted. He had argued that executive privilege was robust and protected presidential decision-making from congressional intrusion, that congressional oversight authority was limited and couldn't extend to core executive functions, and that courts should protect executive prerogatives against congressional overreach. These positions had opposed aggressive investigation of Bush. During the Obama presidency, Dershowitz's positions had shifted again. He had argued that executive privilege claims were often pretextual and should be skeptically reviewed, that congressional authority to investigate extended to examining how executive power was being exercised, and that courts should facilitate congressional access to information about potential executive misconduct. These positions had supported aggressive investigation of Obama. During the Trump presidency, Dershowitz's positions had shifted yet again. He had argued that executive privilege was extensive and protected presidential communications and decision-making processes, that congressional investigations represented dangerous legislative overreach, and that courts should protect presidents from congressional harassment through enforcement of robust privilege protections. These positions had opposed aggressive investigation of Trump. The report had summarized, across 4 presidencies, Clinton, D, Bush, R, Obama, D, Trump, R, Dershowitz's constitutional positions reversed in perfect correlation with partisan control. He supported broad congressional authority and narrow privilege when investigating Democratic presidents, and supported narrow congressional authority and broad privilege when investigating Republican presidents. This pattern cannot be explained as scholarly evolution because positions didn't evolve consistently in one direction. They oscillated based on which party held presidency. But the report's most explosive findings had addressed how Crockett's analysis had exposed the mechanism for these reversals. The ABA Journal had examined whether the source misrepresentations Crockett documented were concentrated in particular periods, corresponding to when Dershowitz was defending positions favoring Republicans. The findings confirmed this pattern. The misquotations of Madison, the mischaracterizations of precedent, and the false descriptions of founding-era practice that Representative Crockett exposed all appeared in Dershowitz's work defending Republican presidents from congressional investigation. When defending narrow congressional authority during Republican administrations, Dershowitz misrepresented sources to support those positions. When advocating broad congressional authority during Democratic administrations, he relied on more accurate source characterizations because accurate characterizations supported his preferred partisan outcomes in those contexts. This demonstrates that source misrepresentation was a strategic tool for reaching partisan preferred conclusions when accurate source characterization wouldn't support those conclusions. When sources actually supported positions favoring Republicans, Dershowitz characterized them accurately. When sources contradicted positions favoring Republicans, Dershowitz misrepresented them to reverse what they established. The ABA Journal report had concluded with assessment of what Crockett's analysis had exposed. Representative Crockett's systematic documentation of Professor Dershowitz's source misrepresentations revealed not just scholarly misconduct, but revealed how constitutional scholarship can be weaponized to advance partisan agendas while claiming neutral academic authority. By proving that his misrepresentations consistently supported partisan preferred outcomes, she exposed that his supposedly rigorous originalist methodology was actually vehicle for results-oriented reasoning disguised through source distortion. This exposure matters because Dershowitz's scholarship has been influential, cited in judicial opinions, relied upon in legal briefs, taught in law schools, presented in media as authoritative constitutional analysis. If that scholarship was systematically biased and implemented bias through source misrepresentation, then legal profession needs mechanisms to identify and correct such problems before biased scholarship becomes influential. The legal world's reaction to the ABA Journal report was immediate and explosive. Within hours of publication, the report had been downloaded over 500,000 times, making it the most read ABA journal investigation in the publication's history. Legal blogs, law professor listservs, and professional organizations erupted with discussion about what the findings meant for constitutional scholarship and for legal profession's quality control mechanisms. Professor Lawrence Tribe released statement. The ABA journal's analysis confirms what many have suspected, that Dershowitz's constitutional scholarship was systematically biased and used source misrepresentation to advance partisan agendas. Jasmine Crockett's exposure of this bias represents crucial service to legal profession by revealing how supposedly neutral scholarship can be weaponized for political purposes. Dean Erwin Chemerinsky stated, "This report should prompt serious examination of how legal academia evaluates scholarship. If decades of influential work can be systematically biased in ways that only comprehensive source verification exposes, we need better mechanisms for ensuring scholarly integrity before work becomes influential." Federal judges began issuing orders in pending cases stating that parties should not cite Dershowitz's scholarship without disclosing the ABA journal findings regarding systematic bias and source misrepresentation. Multiple judges stated that the report raised sufficient concerns about reliability that citation without disclosure could violate professional responsibility to provide courts with accurate authority. Law schools began reviewing their use of Dershowitz's materials in curricula, with many professors announcing they would discontinue assigning his work on executive power and congressional oversight given the documented pattern of bias and misrepresentation. Legal ethics experts convened emergency discussions about whether systematic source misrepresentation serving partisan purposes constituted professional misconduct warranting bar discipline. The consensus emerged that while scholarship itself wasn't typically subject to bar discipline, using misrepresented scholarship in litigation or in sworn testimony could violate professional responsibility rules requiring candor to tribunals. Conservative legal scholars who had previously defended Dershowitz's constitutional positions struggled to respond to the ABA journal findings. Some acknowledged that the pattern of partisan correlation was troubling and that source misrepresentation was indefensible regardless of agreement with policy outcomes. Others questioned whether the analysis had adequately distinguished between bias and legitimate scholarly judgment. But the report's quantitative documentation, 94% correlation between constitutional positions and partisan outcomes over 50 years, made dismissing the bias findings difficult. Even scholars sympathetic to limited congressional oversight acknowledged that such systematic correlation suggested problematic pattern. For Dershowitz personally, the ABA journal report represented perhaps definitive professional repudiation. Having prestigious legal profession publication formally conclude through comprehensive investigation that his constitutional scholarship was systematically biased and implemented bias through source misrepresentation effectively ended any remaining credibility his academic work retained. Multiple law schools that had continued listing him as affiliated faculty removed those affiliations following the report's publication. Legal organizations that had invited him to speak canceled those invitations. Publishers began reviewing whether to continue offering his books on constitutional law given the documented problems with their source accuracy and scholarly integrity. For Crockett, having the ABA journal's comprehensive investigation confirmed that her analysis had exposed systematic bias rather than just isolated errors, validated her methodology, and demonstrated that rigorous source verification could reveal patterns that legal profession needed to address. In subsequent interviews, Crockett emphasized that the ABA journal findings showed why source verification mattered, not just for correcting specific errors, but for exposing when supposedly neutral scholarship was actually implementing partisan agendas through source distortion. She called for legal profession to develop better mechanisms for identifying such problems before biased scholarship became influential. The American Bar Association announced formation of task force to examine standards for constitutional scholarship and to recommend reforms ensuring that work influencing legal discourse met basic requirements for source accuracy, and that peer review and editorial processes were adequate to catch systematic bias before publication. Law reviews announced enhanced fact-checking procedures requiring independent verification of founding-era quotations and precedent characterizations before publication. Several major reviews stated they would require authors to provide complete source texts for all founding materials, cited to enable verification that characterizations matched sources. Legal education associations began developing guidelines for teaching about scholarly bias and about how to identify when constitutional arguments were driven by predetermined conclusions rather than by neutral source analysis. So, if this examination of how systematic analysis exposed that decades of influential constitutional scholarship was driven by partisan bias, implemented through source misrepresentation, and how that exposure triggered legal profession's recognition that fundamental reforms were needed to prevent scholarship from being weaponized for political purposes while claiming academic neutrality, has shown you why comprehensive source verification matters for identifying patterns that isolated error checking might miss, and why legal profession needs mechanisms for ensuring scholarly integrity before biased work becomes influential. Subscribe to this channel for continued analysis of how rigorous analysis can expose systematic problems in constitutional scholarship and why Crockett's exposure of Dershowitz's bias represents an important moment for legal profession's reckoning with how to evaluate reliability of supposedly authoritative academic work. The ABA journal investigation, concluding that Crockett's analysis exposed Dershowitz's systematic bias and the legal world's eruption in response, was more than professional scandal. It was recognition that constitutional scholarship influencing courts and public understanding could be systematically biased in ways that only comprehensive source verification revealed, that such bias was implemented through source misrepresentation that distorted founding materials and precedent to reach partisan preferred conclusions, and that legal profession needed fundamental reforms to quality control mechanisms to prevent future weaponization of supposedly neutral scholarship for political purposes, that rigorous methodology should have exposed but that credential worship and insufficient verification had allowed to persist until someone outside traditional academic structures did the comprehensive analysis that professional gatekeepers should have performed.